Today, we're diving into a critical medico-legal issue that every healthcare professional must understand. What happens if a hospital loses a patient's medical records? Let's break it down in just 3 minutes. In India, the legal framework governing medical records is derived from multiple statutes, including the Clinical Establishments Act, 2010, the Information Technology Act, 2000, and the Indian Medical Council Regulations, 2002. Under Section 13 of the Clinical Establishments Act, every clinical establishment must maintain and provide electronic medical records, or EMRs, or electronic health records, or EHRs. Failure to do so can attract penalties under Section 31, with fines up to Rs 5 lakh. Additionally, the Information Technology Act, 2000, imposes liability on hospitals for negligence in implementing reasonable security practices. Section 43A allows for compensation to the affected patient, while Section 72A provides for imprisonment up to 3 years, or a fine up to Rs 5 lakh for breach of privacy. The Indian Medical Council Regulations, 2002, also play a crucial role. Regulation 1.3.2 obligates doctors to maintain accurate and complete medical records, while Regulation 7.14 mandates that records be preserved for a minimum of 3 years, or until a minor patient turns 18. Under the Consumer Protection Act, 2019, the loss of medical records can be construed as a deficiency in service. Section 242 defines deficiency, and Section 14 empowers the Consumer Forum to award compensation. Now let's talk about the legal implications of losing medical records. First, it constitutes a breach of statutory duty under the Clinical Establishments Act and the Indian Medical Council Regulations. Hospitals may face penalties and disciplinary action. Second, it can be considered medical negligence under the Consumer Protection Act, as it compromises the continuity and quality of patient care. Courts have held that the loss of medical records is a dereliction of duty and can lead to liability for compensation. Third, it may also constitute a breach of privacy under the Information Technology Act, leading to criminal liability under Section 72A. In cases of medical negligence or malpractice, the loss of medical records can severely prejudice the hospital's defense. Courts may draw an adverse inference against the hospital, as held in the landmark case of Martin F. D'Souza v. Mohd. Ishfaq, 2009. In v. Kishan v. Nikhil Super Specialty Hospital, 2010, the court ruled that the loss of medical records constitutes deficiency in service and awarded compensation to the patient. So what can hospitals do to mitigate these risks? First, implement robust record-keeping systems, including EMRs and EHRs, in compliance with Section 13 of the Clinical Establishments Act. Ensure regular backups and data encryption to prevent loss or unauthorized access. Second, conduct regular training programs for staff on the importance of maintaining medical records and data security protocols. Third, in the event of loss, promptly notify the affected patient and the appropriate regulatory authorities, such as the State Medical Council. Fourth, initiate an internal investigation to determine the cause of the loss and take corrective measures to prevent recurrence. Finally, consult medico-legal experts to assess the legal implications and prepare a defense strategy in case of litigation. In conclusion, the loss of a patient's medical records is a serious medico-legal issue that can result in statutory penalties, compensation claims, and disciplinary action. Don't forget to like, share, and subscribe for more legal insights.